Hello and welcome to Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. As usual, to that end, we upload content every day at 8 a.m. Eastern Standard Time. If you like our content, please like, subscribe, and click the notification bell so you can be updated every time we upload new content. With that being said, let's move on to question number 1. In which of the following situations is defendant most likely to be guilty of larceny? A. Defendant took Sue's television set with the intention of returning it the next day. However, he dropped it and damaged it beyond repair. B. Defendant went into Tom's house and took $100 in the belief that Tom had damaged the defendant's car to that amount. C. Mistakenly believing that larceny does not include the taking of a dog, defendant took his neighbor's dog and sold it. Or D. Unreasonably mistaking George's car for his own, defendant got into George's car in a parking lot and drove it home. Take 10 seconds and choose the best answer now. If you chose option C, you'd be correct. Mistakenly believing that larceny does not include the taking of a dog, defendant took his neighbor's dog and sold it. Ignorantia legis. Ignorance of the law is a legal principle holding that a person who is unaware of a law may not escape liability for violating that law merely because they were unaware of its content. Mistake of fact means that if the facts were as the accused honestly believed them to be, they would not have committed the crime. Mistake of fact is a valid defense only if it used to show that the defendant lacked the required mental state for the crime. Larceny is the wrongful taking and carrying away of another's tangible personal property without consent and with the intent to permanently deprive. Here, only C involves a mistake of law. Defendant took his neighbor's dog and sold it, thinking larceny does not include the taking of a dog. Defendant had the intent to permanently deprive his neighbor of his dog and, in fact, sold the dog. Ignorance of the law will not excuse the defendant. Therefore, the situation where defendant is most likely to be guilty of larceny is if defendant mistakenly believed that larceny does not include the taking of a dog when defendant sold his neighbor's dog. If we look at option A, the issue here is that the television set was taken with the intention to return it the next day, so it does not meet the permanently deprive element. Option B, defendant went into Tom's house and took $100 in the belief that Tom had damaged defendant's car to that amount, so he is not then at that juncture wrongfully taking the $100, but in fact paying himself back for the damages that Tom did. So as a result, again, it would not meet one of the elements of this crime. D, unreasonably mistaking George's car for his own, defendant got into George's car in a parking lot and drove it home. The issue there would be is that it is a mistake of fact, clearly. It's not a mistake of law, it's a mistake of fact. He took the wrong car by mistake. He did not intend to permanently deprive George of his car. He simply made an error. Question number 2. In 1963, Hobson was appointed to a tribunal established pursuant to a congressional act. The tribunal's duties were to review claims made by veterans and to make recommendations to the Veterans Administration on their merits. Congress later abolished the tribunal and established a different format for review for such claims. Hobson was offered a federal administrative position in the same bureau at a lesser salary. He thereupon sued the government on the ground that Congress may not remove a federal judge from office during good behavior nor diminish his compensation during continuance in office. Government attorneys filed a motion to dismiss the case. The court should A. Deny the motion because of the independence of the federal judiciary constitutionally guaranteed by Article 3. B. Deny the motion because Hobson has established a property right to his federal employment on the tribunal. C. Grant the motion because Hobson lacked standing to raise the question. Or D. Grant the motion because Hobson was not a judge under Article 3 and is not entitled to a life tenure. Take 10 seconds. If you chose option D, grant the motion because Hobson was not a judge under Article 3 and is not entitled to life tenure. Article 3 states that judges both of the Supreme and inferior courts shall hold their offices during good behavior and shall receive for their services a compensation which shall not be diminished during their continuance in office. An Article 1 tribunal can be created by Congress. Article 1 judges do not enjoy the same protections as Article 3 judges. In this case, the tribunal Hobson was appointed to was an Article 1 tribunal that would review claims and make recommendations. Hobson is not an Article 3 federal judge, which means Hobson is not entitled to the protections of life tenure during good behavior or compensation that shall not be diminished. As such, the court should grant the motion to dismiss the action because Hobson is in fact not entitled to life tenure, nor is he entitled to the non-diminishing salary. Question number 3. Alice was held up at the point of a gun, an unusual revolver with a red painted barrel, while she was clerking in a neighborhood grocery store. Dennis is charged with armed robbery of Alice. The prosecutor calls Winthrop to testify that a week after the robbery of Alice, he was robbed by Dennis with a pistol that had red paint on the barrel. Winthrop's testimony is A, admissible as establishing an identifying circumstance, B, admissible as showing that Dennis was willing to commit robbery, C, inadmissible because it is improper character evidence, or D, inadmissible because its probative value is substantially outweighed by the danger of unfair prejudice. Take 10 seconds and choose the best answer now. If you chose option A, great work, admissible as establishing an identifying circumstance. If specific instances of the defendant's prior bad conduct are being offered to prove anything else that is relevant other than character, then the character evidence rules do not apply and the evidence becomes admissible to prove a mimic fact. Mimic facts are motive, M, intent, I, absence of mistake, there's your second M, or accident, identity, I, and common plan or scheme, there's your C. To prove identity, evidence of prior misconduct that connects defendant to the crime in question is admissible if it is similar and unique. Here, the revolver used to rob Alice was unusual because it had a red painted barrel. Winthrop's testimony that Dennis robbed them using a pistol that had a red paint on its barrel goes toward identifying Dennis as the robber in both cases. Both robberies happened within a week of each other, and both robberies involved a gun with a red painted barrel. Because Winthrop's testimony is being used to prove a mimic fact, character evidence rules do not apply. Accordingly, Winthrop's testimony is admissible as establishing an identifying circumstance. Question number 4. Tess occupied an apartment in a building owned by Len. She paid rent of $125 in advance each month. During the second month of occupancy, Tess organized the tenants in the building as a tenants association, and the association made demands of Len concerning certain repairs and improvements the tenants wanted. When Tess tendered rent for the third month, Len notified her that the rent for the fourth and subsequent months would be $200 per month. Tess protested and pointed out that all other tenants paid rent of $125 per month. Thereupon, Len gave the required statutory notice that the tenancy was being terminated at the end of the third month. By an appropriate proceeding, Tess contests Len's right to terminate. If Tess succeeds, it will be because A, a periodic tenancy was created by implication, B, the doctrine prohibiting retaliatory eviction is part of the law of the jurisdiction, C, the $200 rent demanded violates the agreement implied by the rate charged to other tenants, or D, the law implies a term of 1 year in the absence of any express agreement. Take 10 seconds. Choose your best answer now. I hope you chose option B. The doctrine prohibiting retaliatory evictions is part of the law of this jurisdiction. Retaliatory eviction occurs when a landlord evicts a tenant in response to a complaint from the tenant concerning the condition of the building. A tenant can use retaliatory eviction as both an affirmative defense against an eviction and as cause of action against the landlord. In this case, Len probably evicted Tess in retaliation for Tess's organizing the tenants to make demands of Len concerning certain repairs and improvements. Tess will likely be able to successfully use the doctrine prohibiting retaliatory eviction as a defense against the eviction. As such, if Tess succeeds in contesting Len's right to terminate, It'll be because the doctrine prohibiting retaliatory eviction is part of the law of this jurisdiction. If we look at all of the other options, they're not congruent with the facts, so as a result, B, which is the only one which notes the retaliatory eviction, would be the only sole and appropriate right answer. Question number 5. Kane, a member of the legislature of state, is prosecuted in federal court for a violation of the Federal Securities Act arising out of the activities of a state-owned corporation. Keynes' defense includes a claim that the alleged wrongful acts were committed in the course of legislative business and are immune from scrutiny. Which of the following is the strongest constitutional argument supporting Kane? A, because of doctrines of federalism, federal law generally cannot be applied to state legislators acting in the course of their official duties. B, state legislators enjoy the protection of the speech and debate clause of the United States Constitution. C, a federal court must follow state law respecting the scope of legislative immunity. Or D, to apply the Federal Securities Act to state legislators would violate the Due Process Clause. Take 10 seconds. Choose your best answer now. I hope you chose option A because the doctrine of federalism, federal law, generally cannot be applied to state legislators acting in the course of their official duties. Under the 10th Amendment, all the powers not granted to the United States nor prohibited to the states are reserved to the states or the people. For this reason, Congress is prohibited from compelling state legislative or regulatory activity. The speech or debate clause immunity does not extend to speeches made outside of Congress or to defamatory statements originally made in Congress but later republished in newsletters and or press releases. Article 6 provides that the Constitution and law made pursuant to it are the supreme law of the land. This clause renders any contrary state legislation void. Here, the 10th Amendment serves to limit congressional power over state. If the Federal Securities Act interferes with the state corporation's lawful activities in an area not reserved to the federal government, then the 10th Amendment may protect Kane's official legislative actions from federal prosecution. Therefore, Kane's strongest constitutional argument is that because of doctrines of federalism, federal law generally cannot be applied to state legislators acting in the course of their official duties. Here, the process of elimination leads us to the following choices. B is a bit of a red herring because the speech and debate clause immunity does not extend to speeches made outside of Congress, and Keynes' prosecution is based on activities outside of Congress. C is backwards because state legislation, contrary to federal law, is preempted under the Supremacy Clause. If there is a conflict, the Federal Securities Act would preempt states' law providing for the scope of legislative immunity. There are no facts indicating any violation of Keynes' due process, so D is by then fact eliminated. We are then left with only A. A, as a result, is the correct answer. Question number 6. Ryder, a bus passenger, sued transit company for injuries to his back from an accident caused by Transit's negligence. Transit denies that Ryder received any injury in the accident. Ryder's counsel seeks to introduce an affidavit he obtained in preparation for trial from Dr. Bond, who has since died. The affidavit avers that Dr. Bond examined Ryder 2 days after the transit company accident and found him suffering from a recently incurred back injury. The judge should rule the affidavit A, admissible as a statement of present bodily condition made to a physician, B, admissible as prior recorded testimony, C, inadmissible because it is irrelevant, or D, inadmissible because it is hearsay, not within any exception. Take 10 seconds. If you chose option D, inadmissible because it is hearsay, not within any exception, you'd be correct. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted in that very statement. Hearsay is generally inadmissible because the declarant cannot be cross-examined when speaking out of court, and without cross-examination, it is difficult for the finder of fact to assess whether the declarant is lying or mistaken about the facts stated. Here, Ryder sued Transit Company for injuries to his back from an accident caused by Transit's negligence. Dr. Bond's affidavit would be offered to prove the truth of the matter asserted in that affidavit, that Dr. Bond actually examined Ryder 2 days after the accident and found them to be suffering with a recently incurred back injury. This statement is hearsay and does not fall within any exception. Incorrect answer choices A and B each explain how the closest possible hearsay exceptions do not apply. Therefore, D is the correct answer. Inadmissible because it is hearsay, not within any exception, especially given the fact that you are now not able to cross-examine the deceased doctor. Question number 7. Passer was driving his pickup truck along a lonely road on a very cold night. Passer saw Tom, who was a stranger, lying in a field by the side of the road and apparently injured. Passer stopped his truck, alighted, and upon examining Tom, discovered that Tom was intoxicated and in danger of suffering from exposure to the cold. However, Passer returned to his truck and drove away without making any effort to help Tom. Tom remained lying on the same place and was later injured when struck by a car driven by a traveler who was drowsy and inattentive, had veered off the road into the field and hit Tom. Traveler did not see Tom prior to hitting him. If Tom asserts a claim against Passer for damages for his injuries, will Tom prevail? A, yes, because by stopping and examining Tom, Passer assumed the duty to aid him. B, yes, if a reasonably prudent person under the circumstances would have aided Tom. C, no, if Passer did not in any way make Tom's situation worse. D, no, because Tom himself created the risk of harm by becoming intoxicated. Take 10 seconds and choose what you believe to be the best answer now. Kudos to you if you chose option C, no, if Passer did not in any way make Tom's situation worse. The general rule is that a person does not have an affirmative duty to act. As such, there's no duty to rescue. If a good Samaritan volunteers, then there is an obligation to act within a reasonable standard of care. Another exception arises when the defendant's conduct creates the peril. In this case, Passer examined Tom, but Passer returned to his pickup truck without actually rendering aid. Passer never assumed the duty to aid Tom. Passer would have a legal duty to render aid if Passer had created a peril to Tom by making his situation worse in any way. Accordingly, Tom will not prevail if Passer did not in any way make his situation worse. Looking at option A, yes, because stopping and examining Tom, Passer assumed the duty to aid him. There is no fact that notes that Passer had any affirmative contractual duty. He wasn't a doctor, he wasn't an EMT, he wasn't any of those things on duty, and more importantly, he didn't take any affirmative steps to actually, in fact, help the injured person. So as a result, there's no duty to him, so A would not be appropriate. B, yes, if a reasonably prudent person under the circumstances would have aided Tom again, we have no affirmative duty to act. So regardless of what anyone else would do, the law does not require an individual to act. So B would not be an appropriate response. D, no, because Tom himself created the risk of harm by becoming intoxicated. While this is a good response, and while this is true, in fact, C really is the most appropriate answer based on the law. Simply because at this juncture, Passer stopped, Passer engaged with the injured person. Now, had Passer commenced to present aid, or had he, in fact, made Tom's situation worse, that may have, in fact, affected his potential liability and his exposure. But that being said, given that he did neither of those things, C would be the most appropriate answer here. Question number 8. Peter sued Don for breach of contract. The court admitted testimony by Peter that Don and his wife quarreled frequently, a fact of no consequence to the lawsuit. Don seeks to testify in response that he and his wife never quarreled. The court should: A, the court must permit Don to answer if he had objected to Peter's testimony. B, may permit Don to answer whether or not he had objected to Peter's testimony. C, may permit Don to answer only if he had objected to Peter's testimony. Or D, cannot permit Don to answer whether or not he had objected to Peter's testimony. Take 10 seconds and choose what you believe to be the best answer now. If you chose option B, good for you. May permit Don to answer without whether or not he had objected to Peter's testimony. The general rule is that when a party has testified to a fact of no consequence, The other party is permitted to respond whether or not they initially objected to the testimony. The court, however, has the discretion to exclude even relevant evidence if its probative value is outweighed by unfair prejudice, confusion, or waste of time. In this case, the court admitted testimony that Don and his wife quarreled frequently, a fact of no consequence to the lawsuit. While Don should be given the opportunity to respond, the court has the discretion to exclude evidence due to considerations of undue delay or waste of time. As such, the court may permit Don to testify in response, but the court would not be required to allow it, since this is a fact of no consequence, which the court may exclude if considered a waste of time. Question number 9. Kane, a member of the legislature of state, is prosecuted in federal court for a violation of the Federal Securities Act arising out of the activities of a state-owned corporation. Kane's defense includes a claim that the alleged wrongful acts were committed in the course of legislative business and, in fact, are immune from scrutiny. Which of the following is the strongest argument against Kane's constitutional defense? A. Congress has plenary power under the Commerce Clause. B. Congress may impose liability on state legislators as a means of guaranteeing a Republican form of government. C. Congress does not significantly interfere with state government by applying this law to state legislators. Or D. Congress may impose liability on state legislators by virtue of the necessary and proper clause. Take 10 seconds. Choose your best answer. If you chose option C, Congress does not significantly interfere with state government by applying this law to state legislators, you'd be right. Under the 10th Amendment, all powers not granted to the United States nor prohibited to the states are reserved to the states or the people. For this reason, Congress is prohibited from compelling state legislative or regulatory activity. Here, the 10th Amendment serves to limit congressional power over state. If Congress is not significantly interfering with state by applying the Federal Securities Act to Kane, however, then Kane's federal prosecution under the Act will not run afoul of the 10th Amendment. Therefore, the strongest argument against Kane's constitutional defense is that Congress does not significantly interfere with state government by applying this law to state legislators. Question number 10. Ryder, a bus passenger, sued transit company for injuries to his back from an accident caused by transit's negligence. Transit denies that Ryder received any injury in the accident. Transit company calls observer to testify that right after the accident, Ryder told him that he had recently suffered a recurrence of an old back injury. The judge should rule observer's testimony A. admissible as an admission of a party opponent, B. admissible as a spontaneous declaration, C. inadmissible because it is irrelevant, or D. inadmissible because it is hearsay not within any exception. Take 10 seconds and choose what you believe to be the best answer now. If you chose A, good job. Way to end on a high note. Admissible as an admission of a party opponent. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted in that very statement. Hearsay is generally inadmissible, as we know. A hearsay exemption is admissible because it is not hearsay under the federal rules of evidence. One such exemption is an admission of a party opponent, which is a statement by a party or by someone whose statement gets attributed to that party offered by the party opponent. In this case, Ryder sued transit company for injuries to his back from an accident caused by transit's negligence. Ryder's out-of-court statement to observer that he had recently suffered a recurrence of an old back injury falls under the admission of a party opponent hearsay exemption. So it is admissible. Accordingly, the judge should rule observer's testimony is in fact also admissible as an admission of a party opponent. As always, thank you for joining us on Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. Don't forget to like, subscribe, and click the notification bell if you like our content so you can be updated every time we upload new content.